My Lord, an event arose when my Lord the Chief Justice the benches were reshuffled, and a judgment.
Argue kariye apna case.
And
आप अपना case argue करिए.
my case has been. Allow me to give your Lordship a judgment on the issue.
आप कितना वक्त और लेंगे?
बस 15 मिनट और दे दूँगा अगर questions ना हो तो.
ठीक नहीं.
Lord, this is PLD 1998 Supreme Court 161. Malak Asad Ali case.
PLD?
Malak Asad Ali versus Federation of Pakistan.
This is page?
This is PLD 1998 Supreme Court 161.
Okay, Asad Ali.
Lord, the question was with reference to the entitlement of the senior most person to be the Chief Justice of Pakistan. And the question was there a convention? And if there was a convention, did it have some binding force? This was the question. The Supreme Court, I take your Lordship on page 314, paragraph 95. We are inclined to agree with the conclusion that a constitutional convention once established has the same binding effect as a constitutional provision. I don't want to read the rest of the paragraph. Your Lordship has already said.
So, now I have a question.
Yes.
Are you saying that the senior most judge of the High Court must be made, because there's a convention, the Chief Justice upon the don't interrupt till I finish the question. Upon retirement of the Chief Justice, have I understood you correctly?
No, my Lord. Your Lordship is not. Then your Lordship will have to read the judgment. That judgment says that the senior most judge of the Supreme Court has to be appointed as Chief Justice because there's a convention and there's a past practice. And elaborate arguments have been given. And it is
convention in the High Court generally is to make senior most Chief Justice.
Lord,
So it becomes constitution.
This judgment doesn't talk about the High Court. It talks about the Supreme Court.
बात हो रही ना, असूल की बात हो रही ना,
Sir,
असूलों की बात हो रही है.
असूल वो है जो मेरे लिए जो जजमेंट में है. आप खुद बता
वो क्या आगे बताएं?
आप बता देंगे जो असूल उसके मुताबिक चलेंगे.
आगे बताएं.
जी सर.
आगे बढ़िए.
Similarly, your Lordship held that these rules of the Supreme Court are on a higher pedestal than the ordinary law. And
the judgment है?
My Lord, Khurshid Anwar Binder. 2010, my Lord.
And why the rules are at higher pedestal? Why?
Because these rules they have been made by a constitutional body and
subject to law.
This is part of
subject to law की बात.
Citation तो दे देना 2010.
Khurshid Anwar Binder.
2010.
Sir, मैं भी दे रहा हूँ.
इम्तियाज साहब.
Sir, citation दे दें, मैं पढ़ लेता हूँ, आप बता दें.
This is a constitutional body, and the Parliament Majlis-e-Shura, that is not,
2010
which has
क्या
the
है citation?
exclusive power to make laws.
इसी में
265 PLD 2010 SC 483 विंटर का केस.
इस जजमेंट में आप क्या बताना चाह रहे हैं हमें?
सर, इस जजमेंट में कहा है कि सुप्रीम कोर्ट के रूल्स जो हैं,
कहाँ, किस पेज पे, किस के पैराग्राफ में?
The relevant page is page 535.
535.
And it goes on to page.
नहीं, हमें relevant पढ़ दीजिए ना. 535 कहाँ लिखा है?
It goes on to page 536. The Supreme Court rules.
Thank you.
देखना पसंद करेंगे सर किताब? The Supreme Court rules.
पेज क्या बता? पेज क्या क्या?
Page
Supreme Court rules are on high pedestrian promulgated on the basis of mandate given by the Constitution and not by the government. हाँ, So how does it say it's higher than a law? वो कहाँ लिखा है?
The Supreme Court rules are on a higher pedestal and promulgated on the basis of mandate by the Constitution and not by the government. Objective thereof is to enhance the power of review as conferred by the Supreme Court rules under Supreme Court under Article 180 of the Constitution.
अच्छा, इसमें दो बुनियादी बात हैं जो आप कह रहे थे उसके बरक्स है, और दूसरी बात है whereof was to enhance the power of review.
Sir,
तो ये तो enhance कर दिया था power of review ने.
sir, ये क्या है? ये
लॉ का तो नहीं इसमें जिक्र है,
सर
शायद कहीं और हो, मुझे नहीं पता.
सर इसी जजमेंट को पढ़ें अगर आप डिटेल में, कहने मैं पढ़ना शुरू कर देता हूँ. इसमें
नहीं, ये काम नहीं होता है वकील का. वकील का काम होता है निशानदेही करे फलां सफ़े पे इस पैराग्राफ में. ये नहीं कि मैं पढ़ना शुरू कर देता हूँ. हमें डराए नहीं, आप सिर्फ वजाहत कर दें. मैं पढ़ना शुरू कर देता हूँ.
पेज बता दीजिए प्लीज.
सिर्फ पेज बता दें, हम पढ़ लेंगे खुद. इस पे ये बात नहीं लिखी है जो आप कह रहे हैं इस पेज पे.
536.
हाँ, ये मैंने पढ़ ली. चलें अगला बताइए केस.
अगली जजमेंट लीजिए. PLD 1997 Supreme Court 426. अच्छा इस केस में लॉर्ड. PLD 1997 Supreme Court 426.
Relevant 5 and 9. 1997 PLD Supreme Court.
जी सफा
5 and 9.
511, page 511, 511.
5 and Salim Akhtar give लेंगे. 7 members.
जी 511 पे कहाँ कौन सा पैराग्राफ?
Lord, paragraph 44, the second part of it. Significantly, by employing the word any law, the intention of the Constitution seems to be that Article A will apply to all laws made by the Majlis-e-Shura Parliament, be it general or any law to amend the Constitution. Likewise, no amendment can be made in respect of provision of the Constitution relating to judiciary by which its independence and separation from executive is undermined or compromised. These are built-in limitation in Constitution completely independent from political morality and force of public opinion.
I can agree with this proposition and still dismiss your petition. No, I'm just saying, so I don't know there is anything clincher here in your favor. It says these are built-in limitations in the Constitution completely independent from political morality and force of public opinion. इससे पहला बात है कि separation of executive is undermined. यहाँ तो parliamentary बात है ना, legislation.
May look at PLD 1979 Supreme Court 49.
एक सेकंड, दूसरा बता रहे हैं PLD?
PLD 1979 Supreme Court
1979 Supreme Court.
PLD 1973 Supreme Court 49. Rahman's case.
73, 79.
73.
My Lord, PLD 1973 Supreme Court 49.
No, Rahman.
Relevant page?
Relevant page is 68.
68.
Then it is from 68 to 70, my Lord.
To 70. ठीक.
And
इसी proposition पे.
Please Lordship, Parliament, no law can be made compromising power of judiciary.
ठीक.
Paragraph 70 पे मैं जरा पढ़ना चाहूँगा सर, अगर इजाज़त दे.
ठीक.
May I read?
ये आपने कहा यही proposition.
Yes, sir.
तो हम पढ़ लेंगे, आप पढ़ना चाहते पढ़ लें.
पढ़ना चाहते हैं तो पढ़ लीजिए प्लीज.
My Lord, page 70.
जी.
Exercising paragraph. In exercising the power, the judiciary claims no supremacy over other organs of the government, but acts only as the administrator of public will. Even when it declares a legislative measure unconstitutional void, it does not do so because the judicial power is superior in degree or dignity to the legislative power, but because the Constitution has vested with the power to declare declare what the law is in the cases which comes before it. It is thus merely enforces the Constitution as a paramount law whenever a legislative enactment comes into conflict with it, because it is its duty to see that the Constitution prevails. It is only when the legislature fails to keep within its own constitutional limits, the judiciary steps in to enforce compliance with the Constitution.
होती है
Yes.
जो होता है
enabling
लेकिन
provision
कहाँ पे है
just with the court, it is an enabling provision. How it is applicable here?
ठीक, my lord,
और कोई केस?
it says,
और केस?
PLD 1998 Supreme Court 161 में sir, independence judiciary is a fundamental right.
Page क्या बता दे? Supreme Court.
Page 161,
161. 98 Supreme Court.
His Lordship.
Relevant?
Relevant is page 189,
जी.
page 247.
यही बात है, अलग.
Independent judiciary is a fundamental right. Advocates to ensure independence of judiciary at page 190. Advocates have locus standi, page 191. Constitutional convention as good as constitution, any deviation amounts to deviation from the constitution. 321, page 331.
ठीक.
Certain questions have been asked and I wish to respond to them.
अगर मैं आपके लिए आसान करूं, अगर हम अटॉर्नी जनरल को सुन लें, आपके सवाल हम सुनेंगे वापस, ठीक है? तो वो उनकी तरफ से कुछ एंग्जाइटी थी कि शायद उनको पाकिस्तान को रिप्रेजेंट करना है कहीं, तो वक्त बचाने के लिए आप उनके भी बात को साथ साथ कवर कर लीजिएगा, सवालों को भी कवर कर लीजिएगा, अगर आप ये माकूल तरीक़ेकार समझते हैं। वो फिर चले जाएंगे। फिर
आपकी एक जजमेंट पढ़ना चाह रहा था।
नहीं वो आप पढ़ लीजिएगा, मगर अभी क्योंकि
कहा हुआ है कि बेंचेस रिकॉन्स्टिट्यूट नहीं हो सकती।
नहीं ठीक है,
आपने कहा
भाई
डिपेंडिंग ऑन
रूल, हो सकता है गलत कहा हो, गलतियां भी हमसे हो जाती हैं, वो बात अलग है। मगर हम जरा अटॉर्नी जनरल को अगर आप लोग अग्री करें शॉर्ट ब्रेक करने के बाद, क्योंकि अटॉर्नी जनरल का आपको कहीं जाना है, एक सेकंड, इनके भी हम आपको फिर देंगे हियरिंग, ये नहीं समझें कि आपको हम बंद
सर आई एम डन माय
एक आपको कहीं जाना है।
My lord, there is a hearing scheduled in Vienna on Indus Waters Treaty for 3 days starting tomorrow. So I have to fly out tonight. Tomorrow.
How long will you take?
My lord, today, sir, my submissions will be precise. I've already filed my written brief. I will take 30 minutes, and then whatever questions towards the end my lords may have, I will respond to them and might furnish a response in writing as well. So I have already filed my written brief. I'll take 30 minutes by the clock.
There's vestibule right of audiences with the Attorney General. Have you raised any primary legal objections to maintainability or not?
Yes, my lord, I have a
ठीक है, तो I think we'll take a short break.
My lord.
आप ठीक है, आप अग्री करते हैं? नहीं ये आप भी बातें सुन लीजिए।
Do I have a choice? I don't have a choice. No, I don't have a choice.
You have a
You're most kind. If you agree with me, I'll be obliged.
It's a rare
We will hear you.
My lord, it's a rare moment during these proceedings that I agree with your lordship.
नहीं आपने बड़े
Otherwise, from morning I have not been agreeing with your lordship.
तो आप हम अभी let's say we'll come back at 3 o'clock or 10 to 3 कर लेते हैं।
नाज़रीन, सुप्रीम कोर्ट प्रैक्टिस एंड प्रोसीजर एक्ट 2023 के खिलाफ दरखास्तों पर समाअत जारी थी। फिल वक्त के लिए